Gun Owners of America, Gun Owners Foundation, Silencer Shop, B&T, Silencer Co., Palmetto State Armory, and the Firearms Regulatory Accountability Coalition, or FRAC, have all teamed up to sue the ATF and the Department of Justice over the National Firearms Act. We're calling it the One Big Beautiful Lawsuit. And today, we're going to get into the details of our complaint. I'm Phil, and you're watching Law and Ammo. But before we get into the details of the lawsuit, I want to take a second and let you know about GOALS. The Gun Owners Advocacy and Leadership Summit is set to be held August 9th through 10th of this year in Knoxville, Tennessee. So come out and visit with some of your favorite manufacturers, participate in activism training, and hear from the top voices in the Second Amendment community. And the best part is that it's free for GOA members. So sign up today at gunowners.org/goals. Now back to the video. So as of July 4th, President Trump signed his big beautiful bill into law. But while the bill was being signed, we at GOA were hard at work drafting a lawsuit to challenge the National Firearms Act, doing what Congress wouldn't do with the bill. And for those who don't know, the past year, GOA worked with our allies in Congress on a plan to remove SBRs, SBSs, AOWs, and Silencers from the taxation and registration requirements of the NFA. That was until an extremely partisan ruling from the Senate parliamentarian. She ruled that for the first time in U.S. history, an excise tax was subject to the Byrd Rule. This means that in the Big Beautiful Bill, the registration requirements remain, but the tax is eliminated. And at that point, GOA immediately called for the parliamentarian to be fired. But our calls, and the calls of our allies in Congress, fell on deaf ears. If you'd like to learn more about GOA's fight in Congress to abolish the NFA, I'll link to some of our recent videos on the topic in the description. So because of Congress's failure to remove registration requirements, we're suing to do so. We filed our lawsuit in federal court, specifically in the U.S. District Court for the Northern District of Texas, San Angelo Division. The basis of our suit is the fact that Congress passed the National Firearms Act in 1934 based on their ability to tax. In fact, the NFA's authors left no doubt that the NFA was an exercise of taxing power, and the Supreme Court upheld it on the basis that Congress has the power to tax in the 1937 case of Sonzinsky versus United States. This view, that the National Firearms Act is a tax, has been the uncontroversial understanding of courts and commentators for nearly a century. But now the NFA no longer imposes any tax on the vast majority of firearms it purports to regulate. And that's all because the One Big Beautiful Bill Act, which Congress and the President enacted on July 4th, 2025. The act zeroes the manufacturer and transfer tax on nearly all NFA-regulated firearms. That means the constitutional foundation on which the NFA rested has dissolved. In our lawsuit, we cite another case from the 1930s, United States v. Constantine. In this case, the Supreme Court ruled that a provision that does not generate revenue cannot be justified as a tax. Interesting. And so with respect to untaxed firearms, the National Firearms Act is unconstitutional. That's because of the registry. In furtherance of ensuring the collection of the tax imposed by the National Firearms Act, the NFA established a central registry for recording the makings, transfers, and corresponding tax payments of the firearms subject to the NFA. This registry, called the National Firearms Registration and Transfer Record, or NFRTR, exists solely to ensure that firearms have their tax stamp paid up. Any NFA-regulated firearm not registered with the NFRTR is in violation of the law and subject to healthy penalties, including 10 years in prison and $250,000 in fines. Additionally, the tax imposed by the NFA, nearly $5,000 per firearm in today's dollars, was a pretextual attempt to prevent average citizens from possessing NFA firearms. Not to mention the fact that the NFA is a tax on a constitutional right, regardless of whether the Supreme Court has justified it under Congress's taxing power. And so let me list out the counts from our complaint in the case GOA v. ATF. Count 1, declaratory judgment that the NFA's registration and transfer requirements exceed Congress's Article 1 enumerated powers with respect to untaxed firearms. Translated from legalese, the NFA's registration, manufacture, and transfer requirements pertaining to untaxed firearms exceed Congress's enumerated powers. That's because all of those requirements were enacted and sustained as an exercise of Congress's taxing authority. The Supreme Court case Sonzinsky v. United States confirms this point. Now, SBRs, SBSs, AOWs, and silencers are untaxed, but the registration requirements remain. We're claiming that our plaintiffs, GOA members, are more than injured by the NFA's unconstitutional requirements and are entitled to a declaration that the NFA's registration and transfer requirements exceed enumerated powers. Count 2. Injunctive relief against federal officials from implementing or enforcing NFA with respect to untaxed firearms. Once again, translated from legalese, we're asking for a permanent injunction against the defendants, the ATF and Department of Justice, from implementing or otherwise enforcing any part of the NFA that pertains to untaxed firearms. We're also arguing that the NFA has harmed our members in various ways. Many GOA members wish to purchase, obtain, make, or otherwise possess and transfer NFA-regulated short-barreled firearms and silencers, and they would do so but for the NFA's onerous federal registration requirement. Other GOA members and supporters currently own NFA-registered firearms, but they object to the federal government's continued retention of their registration information. In addition, we also cite ways that our co-plaintiffs are harmed by the NFA as well. For example, here's what Silencer Co. had to say. By virtue of the continued federal registration requirement for firearm silencers, Silencer Co. suffers from a restricted market and artificially limited sales. Silencer Co. has heard from many prospective customers who have indicated that their sole deterrent from purchasing one of Silencer Co.'s products is the federal registration requirement. We're excited to finally be able to take this fight to one of the pillars of gun control in this country, the National Firearms Act. And as always, we'll keep you updated on the case as it progresses. I'm Phil. Thanks for watching Law and Ammo.